My name is Hayley Mansfield. I'm the Executive Officer of ARC Justice, which incorporates the Loddon Capacity Community Legal Centre. Welcome to Talking Justice 2017 and what promises to be a very exciting day. I'd like to acknowledge the traditional owners, the Dja Dja Wurrung, and pay my respects to their elders past, present and future. And also say thank you once again to Rodney Carter, who last night gave a beautiful welcome to country and spoke about the importance of events such as this and Indigenous justice. It was a wonderful evening last night. It was great to have the Chief Justice here and talking about family law, and we had three other family law specialists. And I'd also like to say thank you to Boomtown, who provided drinks and sponsored last night after the event. A couple of housekeeping things before we kick off. Toilets are just out here. If you head out through the door and turn right and go up through the foyer, they're on your right. And also to let you know that did everybody get a program? Has everybody got a piece of paper? Yep, a few nodding heads. You've got a number on that there that throughout the session today you can text questions in and we'll be passing those to our moderator to put to the panel. That is everything from me. I'm going to be handing over to our host, Damien Carrick, who will lead the panel discussion today. Enjoy your session. Thanks.
Good morning, everyone. Welcome to Talking Justice, or welcome back if you came to the event last night. Our first panel discussion today will explore the Victorian Government's response to recent riots in youth detention facilities. Should children ever be transferred to adult prisons? Should they be managed by the Department of Human Services or by the Department of Corrections? Are the concerns of human rights lawyers justified? And why recently, I think it was on the 11th of May, did the Supreme Court of Victoria rule that kids must not be held in adult jails? And looking into the future, what sort of youth detention regime do we want to build and work to? The organisers of Talking Justice sought to get a range of perspectives for this panel. They approached the Department of Justice, the Department of Human Services, Victoria Police, the local state MP and the Herald Sun. And unfortunately they were all unavailable to participate today. Now, these issues do affect central Victoria. You've got Malmsbury Youth Detention Centre just down the road. And I think we do have to be very clear-eyed when we have this kind of discussion. Back in January, 83-year-old Bendigo pensioner Herman Kleinhut was heading off to visit his wife's grave. 4 teenagers, part of a group of 30 who'd just escaped from Malmsbury following a riot, carjacked Herman, pushed him out of the car and left him on the side of the road. I think this group of 4 of about 30, as well as carjacking, were involved in aggravated burglaries, armed robberies, using weapons such as knives and baseball bats and stealing cars before they were arrested. Now, we're going to be talking about what the best public policy is around juvenile detention, but we acknowledge the serious impact of crime on victims and people like Herman, people in the Bendigo community here. Now, our first speaker is Claudia Fatone, and Claudia is the Executive Officer of the Fitzroy Legal Service, a position she's held since 2013. She's also a board member of the Victoria Law Foundation, and she's also a director of Cricket Victoria. And Claudia is also a mentor with the Assister Mentoring Program, which matches young women with volunteer mentors. Now Claudia is going to speak about some of her clients and the recent litigation that saw the removal of children, I think it was on May the 11th, from the Grevilla unit at Bowen Prison. Would you please make Claudia welcome?
Thanks, Damien. I too would begin by acknowledging that the City of Greater Bendigo is on the Dja Dja Wurrung and Tarrangung country, whose ancestors and descendants are the traditional owners of this land, and pay my respects to elders past and present and to any First Nations people who may be in attendance today. So the question, as Damien has outlined, is youth crime. Should we treat young people Should we treat children in detention the same as adults? So interestingly, we treat children under 18 different to adults in a whole range of other factors of our community lives. Drinking alcohol, driving and voting. So why should justice be any different? I'll come back to that point a bit later on. On the 2nd of December 2016, the Fitzroy Legal Service, in conjunction with the Human Rights Law Centre, lodged a challenge in the Victorian Supreme Court seeking the removal of young people that were being held at the Grevillea unit of the Bowen Adult Prison. Bowen Prison is a high-risk, maximum security prison established to house the worst adult male offenders in Victoria. For context, I'll provide a brief overview of the incidents leading up to our challenge and outline decisions of the court in our challenge and the more recent one launched by the Human Rights Law Centre. On the weekend of the 12th and 13th of November 2016, a series of incidents occurred at the Parkville Youth Justice Centre, which resulted in significant property damage at the centre. And on the 15th of November, 7 applications were lodged with the Youth Parole Board to transfer 7 young people to Bowen Prison. The Youth Parole Board rejected all 7 applications, and they referred to the criteria that was set out in the Children, Youth and Families Act that applied to young people under a children's court sentence as stringent tests protective of that age category. And the language is really important. Protective of that age category. It gives us an indication upon the very basis on which the Victorian youth justice system is predicated. Protection of young people, focus on rehabilitation and successful reintegration into the community. So hence, until recently, youth justice was the responsibility of the Department of Health and Human Services and not the Department of Corrections, which manages the adult justice system. On the 17th of November, 3 orders of council were published in the Victorian Government Gazette. And the practical effect of these orders was to excise the Grevillea unit at Bowen Prison and to establish it as a youth justice and remand centre. Over subsequent days and weeks, a number of young people were moved to Grevillea from Parkville and Malmsbury youth justice centres. On the 22nd of November, the Victorian Aboriginal Legal Service commenced a proceeding alleging that the detention of Aboriginal and Torres Strait Islander children at Bowen Prison was unlawful. And a week later, the Secretary of the Department of Health and Human Services undertook that she would not place any Aboriginal and Torres Strait Islander children at Bowen Prison for a period of 18 months, unless in exceptional circumstances. So as a result, Aboriginal and Torres Strait Islander children being housed at Bowen were removed. However, there still remained in Bowen a number of other young people not of Aboriginal or Torres Strait Islander descent. Following a 4-day trial in the Victorian Supreme Court to hear the Fitzroy Legal Service challenge, Justice Gard issued a judgment on the 21st of December. And I won't go into too much of the legal argument, but essentially Justice Gard ruled that the Minister, when making the orders to establish the Grevillea unit in Bowen as a youth justice centre, did not take into account relevant considerations that were required to be taken into account by making that decision. And these relevant considerations included the purposes of the Act, the specific purposes of a remand centre and youth justice centre, the duties of the Secretary, and the entitlements of detained young people and how they would be met in the new location. Further, Justice Gard said, and I quote, "Essentially, the Department and the Minister were flying blind as to the real situation and suitability of the Grevillea unit when the orders in Council were made," unquote. Furthermore, Justice Gard said, quote, "When the Grevillea unit was occupied, the Department was quite unprepared to meet the demands on it to comply with the Secretary's duties, or to provide young persons with their entitlements. It found itself unable on the occupation of the facility to cater for the developmental needs of young persons, receive visits, or provide for medical or religious needs. It did not provide information to young people who had been relocated to Grevillea. No attention was paid to the form of protection, care, custody, or treatment that was in the best interest of the young persons transferred to the Grevillea unit. The Victorian Government subsequently appealed this decision and received a stay, arguing that there was no place to remove the children to. This meant that the young people had to remain in Bowen Prison until the appeal was heard. This was mid-December, which meant that these young people remained in Bowen Prison and spent Christmas there. Our clients described some of the conditions in the Grevillea unit at Bowen Prison to us. They were hungry, the food provided was not substantial enough. Dinner was served at 4 p.m. and nothing until breakfast the next morning. They had difficulty in accessing visits from family members. It was too far away, there was no public transport, leading to feeling of loneliness and disconnection from their families. There was a lack of access to educational programs and recreational activities, leading to boredom. There was nothing to do all day. Remembering that these are teenage boys. The Court of Appeal, the Supreme Court, heard the government's appeal and made a ruling on the 29th of December that no error had been made in Justice Gard's finding that the Minister failed to take into account relevant considerations. It essentially upheld the initial decision. The Victorian Government then immediately re-gazetted the Grevillea unit, noting in their press release that the issues raised by the courts had been addressed in the new gazettal. This meant that young people continued to be housed in the Grevillea unit of Bowen Prison. The Human Rights Law Centre lodged a new challenge in 2017, with Justice Dixon of the Supreme Court ruling on Thursday the 11th of May that the Grevillea unit of Bowen Prison's reclassification as a youth justice and remand centre in December was incompatible with the children's human rights and to have their best interests protected. Due to this decision, all young people have now been moved out of Bowen Prison. The factors which led Justice Dixon to make this ruling were the impact of Grevillea's built environment on the youths who were children detained there, which was and remains that of a maximum security adult jail. The extensive incidence of isolation by lockdown for substantial periods of the day, extending up to 23 hours, in cells designed for occupation by adult men. The continuing use of handcuffing in order to move detainees between one wing of Grevillea and the outdoor exercise area. A failure to consider the heightened risk of detainees developing mental health problems directly relating to the environment in Grevillea, including depression, anxiety, cognitive problems, hypersensitivity and paranoia, or the exacerbation of existing mental health conditions. And the limitations on the developmental needs of detainees, specifically their physical, social, emotional, intellectual and spiritual needs that were affected by the use of Grevillea as a youth justice precinct. For the Fitzroy Legal Services specific challenge, despite 2 Supreme Court rulings in our favour, it didn't achieve the desired outcome, which was to remove all young people from Bowen Prison. So hence the obvious question, what did we achieve with our litigation? In our view, regardless of the outcome, we shone a spotlight on the issues of young people in adult detention. We sought to provide a balance to the debate that was occurring in the media and the community about youth crime, the notion that youth crime was spiralling out of control, that we need to get tougher on young people, tough on crime. And whilst there was a lot being spoken about the young people in the youth justice system when they've hijacked cars or burgled homes or rioted, rarely had the voices of these teenagers or their families been heard. In our work at the Fitzroy Legal Service, we support defendants, victims and families. We have found a way to assist many different community members with a variety of legal issues. We provide assistance to young people involved in the criminal justice system and knew some of the individuals that had been moved to Bowen Prison from Parkville or Malmsbury. We certainly don't seek to downplay the seriousness of criminal offending that leads to our clients and other young people being detained in youth justice centres. What we do know, though, are some of the key factors that influence this offending. Children in the criminal justice system often come from very disadvantaged backgrounds and have complex needs. Many of these children have experienced trauma, family violence, child abuse, often resulting in them coming into contact with the child protection system and being placed in residential care. Many have a family history of involvement in the criminal justice system, a parent or a sibling who has been imprisoned. Many are using drugs. Food, education, jobs, structure, family. Things that many of us take for granted. A lot of these young people don't have that on the outside. Some of them as young as 11 when they were first locked up. In response to the issues facing the youth justice system, an inquiry was launched by the Victorian Parliament's Standing Committee on Legal and Social Issues. Some of the young people being detained at Parkville Youth Justice Centre contributed letters to this inquiry, and two comments in particular stood out for me, and I quote, "If you grow up in a family or community where crime is normal and violence is normal, you grow up thinking that's what life is meant to be like. By the time you realise it's not, you're kind of already in that world and you're doing things that are really hard to stop doing," unquote. And the second comment, "You can use drugs and then you need money to get more, so you do awful stuff that you shouldn't. And then you feel ashamed of what you've done, and so you think it doesn't matter anymore. So you do more of the bad stuff that makes you feel shame, and then you end up in here," unquote. Most of the focus on the riots that occurred at Parkville in November was on how to deal with the individuals involved. The question that really didn't get asked was, why did the riots occur in the first place? The system had been going well for such a long time that it became neglected. Overcrowding, understaffing, and a punitive approach all fuelled unrest in the Victorian youth justice system. The sector lost a large number of highly experienced staff in the years following a public sector purge of jobs, and this led to a loss of expertise and people with that deep knowledge on how to work with troubled young people. Perhaps understandably, the response of frightened and under-resourced justice workers to challenging behaviours has been to resort to increased use of isolation and lockdowns. And overcrowding is not about more offenders being sentenced. Most of the new detainees in the past year were on remand. The uncertainty of being on remand generates great anxiety and frustration amongst young people. Aside from the overcrowding and staff shortages, those who have worked in the Youth Justice Centre for some time point to a shift in culture, to a more punitive and restrictive system within the centres at the expense of rehabilitation. There was a recent article in the Law Institute Journal that interviewed one youth justice worker who recently quit his position at Parkville. He says he originally applied for the job with the impression he'd be working in a therapeutic, social justice, social work type of role. That's what the advertisement said, but what I ended up being was just a guard. The issues around youth crime and the youth justice system are highly political. We have both the Victorian Government and the opposition trying to outdo each other in the tough on crime stakes. In the wake of the riots at Parkville in November, Premier Daniel Andrews said he and the community were sick of the disgraceful behaviour in youth detention. Those inmates will be going to adult prison and I make absolutely no apology, he said at the time. And as reported in The Age on Friday the May 12th, Opposition leader Matthew Guy agreed that the inmates deserved no apology for human rights breaches, saying the decision to put teenagers into the secure facility was the right one. One of our elected officials here in Victoria stating that there should be no apology for human rights breaches. You might start with youth justice, but where do you extend that line of thinking to? And if you think about the language used in media reporting on youth crime, child thugs, teen misfits, youth gangs, there is no doubt that media focus influences decision makers and the community. My dad is a prime example of the influence of media, proceeding to fortify his house in the northern suburbs of Melbourne for fear of the Apex gang, despite the fact that the family home has been untouched by crime in the 40 years my parents have lived there. Claims of youth crime wave must be kept in perspective. While police have identified a pattern of serious offending by a very small cohort of young people, youth offending is generally otherwise in decline. Compared to 5 years ago, there has been a drop in the number of children and young people under 18 engaging in crime. In the wake of the revelations about the Northern Territory's Dondale Detention Centre, a Royal Commission was established. And the former Northern Territory's Corrections Minister, John Elferink, told the Royal Commission that being seen to be tough on crime was a vote winner. despite the fact that there was no evidence that such an approach had any benefit. The media has almost exclusively framed youth as a justice problem, rather than a key element of our community's future success. Children's unique vulnerabilities have been overlooked in this debate, and their voices have been sidelined from the conversation. I'll now refer back to my original comments. As a society, we treat children under 18 differently to adults in a whole range of other areas: driving a motor vehicle, drinking alcohol, voting. So why should justice be any different? Those who agree that young people should be punished for their crimes and that an adult prison is an appropriate place to house them have an assumption that physical maturity signifies psychological maturity. You've probably heard this. These aren't young people or children. They are the size of grown men, so they should be treated as such. Adolescence is a critical phase of brain development. The rational part of a teenager's brain isn't fully developed and won't be until the age of 25 or so. And in fact, recent research has found that adult and teen brains work differently. Adults think with the prefrontal cortex, the brain's rational part. This is the part of the brain that responds to situations with good judgments and an awareness of long-term consequences. Teenagers process information with the amygdala. Sorry, I'm not a scientist. This is the emotional part. In teenagers' brains, the connections between the emotional part of the brain and the decision-making centre are still developing, and not necessarily at the same rate. As they grow, children develop the mental skills and the abilities they will need to function throughout their lives. Key capacities like the ability to focus, pay attention, and ignore distractions begin to develop in early childhood when they require plenty of practice and support, but they aren't completely operational until people reach their mid-20s. Brain development links to the assumption that crime is a rational decision, that young people weigh up the costs and benefits of committing a crime and choose their behaviours based on the likelihood that they're going to get caught. Hence, the conclusion for government and a lot of people in our community is that the only way to decrease crime is to make punishments harsher. Our juvenile justice system works like a maze, with many entrances but few exits, so youth get stuck in it. We need to redesign it with fewer entrances so we can reroute youth instead to more effective treatment options, like drug and mental health treatment. To ensure good youth outcomes that contribute to our community's safety and well-being, we need practical juvenile justice policies and programs based on proven, age-appropriate interventions, which may include detention as a last resort, but it must be an age-appropriate detention facility. We know that adolescence is a time of rapid brain development, which affects youth's judgment, decision-making and behaviour. For that reason, it makes no sense to treat youth as adults, including placing them in an adult maximum security prison. Instead, we can achieve better outcomes by keeping children and teens out of the system through diversion programs, mental health treatment and other interventions, practices that are both feasible and in line with modern understanding of adolescent development. In the recent Victorian State Government budget, $288 million has been allocated for a new Supermax youth justice system. This was a missed opportunity to create a world-class youth justice system that reduces disadvantage and ultimately keeps the community safe. $288 million for a 224-bed Supermax facility. You do the maths. That's over $1 million per bed. Is that really money well spent? Where are the dollars for initiatives that actually have been proven to work? Thank you.
Thanks, Claudia. Our second speaker this morning is Liana Buchanan. Liana is the Principal Commissioner for Children and Young People. Now, prior to her appointment as Commissioner in April last year, her roles included being the Executive Officer of the Federation of Community Legal Centres, where she led a sort of a peak body for Victoria's 50 community legal centres. And she's also Director of the Office of Correctional Services Review, where she's responsible for monitoring Victoria's correction system. Would you please welcome Liana Buchanan? Thank you.
Thank you. I too will start by acknowledging the traditional owners of the land we're meeting on today, the Dja Dja Wurrung, and pay my deep respects to their elders past and present, and indeed future elders, which is important to me, particularly bearing in mind my role as Children's Commissioner. When I acknowledge country, I acknowledge the harms that have been done to the first peoples of this land. And we see the legacy of those harms in most parts of society that we care to look. But for the purposes of the conversation this morning, let's look at youth justice and just bear in mind that Koori kids are 12 times more likely to be in the youth justice centres that we are talking about today. And if you look nationally, the figures are even worse. Look, thank you so much for inviting me to talk justice today on a topic that has consumed a lot of my attention in recent months. When I was thinking about what to talk about, I held off until the very last moment. Damien and Claudia, who I spoke to during the week, can affirm that. But that was primarily because this has been such a volatile area, has been such a movable feast. If I think about when the organisers of this program would have settled the topic for this morning's session, nobody would have known whether the children Claudia's just been talking about would still be in the Barwon prison or whether they'd be moved. Now, as we've just heard, just over a week ago, the Supreme Court handed down the latest decision, and those children and young people have been moved out of Barwon, for which I think we can all be pretty pleased and relieved. And I think in part what that means is that we can have a slightly different conversation this morning. We can have a conversation, certainly this is what I'm keen to do, that reflects a bit about how the prospect of children in an adult maximum security prison ever came about, how we can try and stop it from coming about again, and what are the remaining ongoing issues in the youth justice system. Because as I'll come back to, I'm very, very keen to emphasise that our work is not done. The decision was a significant one just over a week and a half ago, but we have a lot of work to do. In this session, we've been asked to look at the Victorian Government's response to the riots in November that Claudia has taken us through. And I'll do that, but I'm going to look a bit more broadly than November, because I think, and Claudia herself has taken us through some of that, we've got to look at those riots in context, what led up to those, and we've got to look at the Victorians' actions in context as well. As Commissioner for Children and Young People, part of my role is to monitor and provide oversight to systems that affect vulnerable children, and there's a specific focus in the legislation that sets up my role on vulnerable children, which includes child protection, out-of-home care and youth justice. I have to say, when I came into my role just over a year ago, not that long, I thought that the high-profile stuff that I'd be dealing with would be in the child protection and out-of-home care space. I didn't for a second imagine we'd be where we are today on youth justice. I thought youth justice, from a bit of a distance, was pretty settled. I also thought the community conversation about youth justice was relatively settled. I thought there were a number of accepted fundamentals, if you like, that were accepted not only in the community, largely with the occasional blip within the media, and importantly, across all sides of the political spectrum. I thought that it was a given that we needed a separate youth justice system to deal with children who offend, that reflected some of the differences that Claudia's taken us through about children, the fact that their brains are still well and truly developing, and that has a whole range of different implications. I thought that it was a given that we should have a system that should focus on rehabilitation as its primary purpose. I thought it was a given that we should have a system that recognises the vulnerability of children, and the fact that most children who get caught up in offending, to the extent they end up in youth justice centres, have experienced significant disadvantage and, in large part, incredible trauma. The stats, hopefully if you've been listening to advocates, you'll have some of these stats. If you've just been paying attention to the media, you won't. But 2/3 of the kids in the youth justice centres in Victoria have been involved in child protection and under orders in the past or are under child protection orders now. That means 2/3 have been involved in and victims of abuse, neglect, trauma, the kind that most people happily can't even imagine. When you look at the extent of mental health issues, we've got 1/3 of the kids in those centres have diagnosed mental health issues, let alone the undiagnosed, and 1/5, almost a quarter in fact, have impaired cognitive functioning. That's just a few of the aspects of the children that we're talking about that are worth bearing in mind. I thought that it was a given that we needed to pay attention to the evidence that tells us that punitive, restrictive approaches aren't only inhumane when we're talking about the younger members of our community, but they don't work. They actually compound the harm. And I thought that the kind of tough-on-crime narrative that we are so familiar with in the adult space, we're so familiar with when it comes to adults who offend, I thought that for children, we were a little bit protected from that. I was wrong. All of these supposed fundamentals are now far from accepted truths in our community dialogue and our political dialogue. We have a new narrative. Claudia's taken us through some of that. But I'll go back. I'll go to March last year, just before I started as Commissioner, as it happens, and the Moomba weekend and what's now widely known as the Moomba riots. And really what I saw from there, right through in the lead up to November, and we'll deal with post-November in a minute, an absolute steady, almost relentless focus on youth offending. Often, of course, as we know and we've seen, with a particular racial focus. And it was, it really was relentless. Every week, if not every day, we'd see stories on the home invasions and the carjackings. We'd see a mounting narrative about a youth crime wave, even though, as we've heard, the numbers of young people who offend are going down, and in fact what we were talking about and what we were seeing profiled was a relatively small number of a couple of hundreds. So the Victoria Police says at the most it's about 500 young people. The Crime Stats Agency says it's about 200. Either way, we're talking about hundreds, not thousands or more, hundreds of young people caught in this pattern of more serious offending. So there's a new narrative. We have to clamp down on violent teen thugs. We have to toughen our penalties and create new offences. We need a supermax facility for young people. We see the government in May last year absolutely lambasted for being soft on crime because the government reversed some bail changes that had, over the prior 3 years, led to a massive hike in the number of children being remanded. Again, Claudia alluded to this, but at Parkville, we now have on any given day 80% of the kids in there are on remand. A few years ago, it was the other way around, it would be 20%, so there's been a massive hike. But when the government made attempts to address that, it was roundly criticised. We've seen calls for an end to the differential approach to children who commit crime. So this was the dominant narrative in the lead up to November. It was the opposition, it was the mainstream media in spades, it was the Police Association, it was the union, the CPSU, a very varied and growing range of stakeholders really calling for a tougher approach to kids. And at the same time, what was happening inside the youth justice centres is that they were becoming less settled, or at least the extent to which they were less settled was becoming more visible. We saw an increasing number of incidents that then played out in the media and added fuel to people's alarm and tension. So that was the context up until November. But if I thought that we'd strayed from the accepted fundamentals, as I call them, before November, I hadn't really seen anything yet. Claudia's talked to us about the riot in mid-November. As she said, it caused massive damage to the centre, putting 60 beds out of action. There was, at that point, a very real capacity problem that government had to contend with. I understood that at the time, and for that reason, my position publicly and generally was, I think we have to look for other options beside Barwon, and I think we have to keep looking for them because Barwon is not a good option. But if government is adamant in that emergency situation that there are no other options, then what's really important is that the children who move to Barwon are treated in a way that's comparable with the way they're treated in the other centres, at least, that they're managed by youth justice staff, and that they don't experience a worsening of conditions and a lesser access to some of the things they need because of those decisions. So again, we've heard that children were moved into Barwon. I was pretty dismayed the first time I went to visit children, and that was 2 days after the first had been moved in there. As Damien mentioned, one of my past roles was to head up the unit that oversees the adult corrections system in the Department of Justice. So the last time I'd been into Barwon was when we were investigating the death of Carl Williams. It was pretty grim to go in there to visit and talk with 15-year-old boys. And it was more grim when I went in and saw the way those children were being treated. Now, conditions changed and improved over time, but in those early weeks particularly, they were appalling. There was standard 23-hour lockdown for all children. That translates to just 1 hour out of cell. That's kind of probably a more compelling way to remember to phrase it. And all the issues that Claudia mentioned were playing out. Kids hadn't had any phone contact with family. They weren't having visits. They were at that stage having no fresh air time and didn't for a few weeks. There were a whole range of pretty appalling circumstances that led me, and this is well and truly on the public record because the Ombudsman's published all my letters to the Minister from that period, but it led me to write to the Minister saying we are keeping children in harsher conditions than the most restrictive regime available in the adult corrections system, and that was absolutely the case. Now, as I've said, conditions improved gradually, although sometimes they went backwards. By January, again, I was raising concerns with the Minister that although not all children were being locked down for 23 hours, that was a fairly common occurrence whenever there had been an incident or some misbehaviour. There was a standard application of what's called a separation plan with a standard 23-hour lockdown component. And when those children were let out for their 1 hour, they were on handcuffs for the entire time, again, not subject to any particular risk assessment, and a whole range of other problems playing out, as well as staff shortages, and I'll come back to this when I talk about the rest of the system, but also at Grevillea, staff shortages sometimes were meaning that children, even if they hadn't been involved in an incident, were only able to get out of their cell for 3 hours a day. And of course, and this is worth remembering, later in January we had Corrections Victoria staff based in the Grevillea unit, armed with batons and capsicum spray, full-time mixing and there as part of the staffing complement. So some of my absolute preconditions around if we're going to have kids in this environment, we have to mitigate the impact and we absolutely have to make sure that they're still managed by youth justice staff. Well, that well and truly shifted as time went on. So my answer to one of the questions posed for us this morning, should children be transferred to adult prisons? Of course not. Grevillea is a unit that is unmistakably designed and built for adult maximum security prisoners. It's harsh, it's bleak, it's unforgiving, it's cold, it's incredibly contained. Talking to kids as I have done and did over the months that they were there, they found the very environment pretty hard and pretty frightening at times. Its infrastructure alone there makes it inappropriate for children, particularly when you think about the backgrounds of these children, the fact that we are talking about children who are by very definition, by their very age, they are vulnerable and they're still developing cognitively and emotionally, but also many of them have backgrounds not only of disengagement and exclusion but significant trauma. But I think one of the most significant things that I would add is the infrastructure alone was a problem, but actually the way that the system was working with those children and treating those children actually made things much, much worse. There were several points in time over the months that the children and young people were in Grevillea, particularly those early months, that I was really conscious that although I, in my role as someone who can scrutinise the system, was going in to Grevillea frequently, and commission staff were going in either twice a week or after the initial few months once a week. And although I was raising my concerns with the minister fairly frequently by letter and increasingly speaking out about my concerns, I wasn't always taking exactly the same line as other advocates. I wasn't, and held off at any point from saying get the kids out of Grevillea no matter what. And the reason that I didn't do that was because it seemed clear that, right or wrong, if government was going to move the kids out of Grevillea, they were going to move them into Parkville and Malmsbury, where there were still, up until relatively recently, there were still 60 beds short, and there were some pretty significant capacity problems. But I'd been worried about those centres since almost as soon as I walked into the role. I'm on the public record talking about some of the things that I've seen in the past year in Parkville and Malmsbury. I'm on the public record talking about the fact that I've had reason to do several reviews into incidents where children have had limbs broken through inappropriate restraints. I'm on the record talking about the fact that at Parkville, children, the younger boys, 10 to 14, and the girls have been subject at times to routine handcuff regimes whenever they leave their unit. So just to go to programs or just to go to gym, they've been put on handcuffs. I'm on record talking about one of our community visitors who saw one day that a young child had blood on the back of their top. And when they looked at it, it was because those handcuffs were opening up self-harm wounds. I'm on public record because I've tabled a report in Parliament about this, that we have looked over the past couple of years at the extent of isolation and lockdowns in our youth justice centres. I'm on record saying that when we looked at that, and we looked at it very closely, and it took us some time because the recording and the data, frankly, was very, very hard to find, and even at the end of it, incomplete. But what we found clear evidence of was excessive use of isolation as a major behaviour management tool, if not the main behaviour management tool. We found evidence of children and young people kept in isolation for up to 40 days at a time. We found evidence of children being kept in isolation spaces at Parkville where there are no sanitation facilities and children were forced to relieve themselves in the cells on the floor. We found evidence when we watched footage of children who were in isolation spaces because there were a risk of self-harm, banging their heads for 6 minutes or more against the wall with no intervention from any staff member. And on top of all of that, we found evidence that, again, for at least the last few years, but actually the evidence suggests longer, staff shortages at centres have meant that children have been frequently locked in their cells and secluded and are not able to go to education or access the other programs they need. Again, not because they've misbehaved, not because they've been involved in any incident or because they're a risk to themselves or others, just because we haven't been able to get enough staff to open up units. When we looked at the data, we found that on average, over the 18-month period that we looked at, which was actually before November last year, that 18-month period finished in mid-2016, on average every day there was at least one unit of 15 kids locked down, at least for an hour, often for a couple of hours, sometimes half a day, sometimes longer. So I guess what I want to encourage us to do today, and I'll finish here, is yes, we absolutely have to think about how it came to pass that we had kids in Grevillea. We absolutely have to be pleased and relieved that the courts gave our decision makers a reminder that the rights of these children matter and that we do need to protect and have a separate system for kids. But I'm pretty keen to make sure that we also have the conversation about the situation for children and young people who are in Parkville and Malmsbury today, about how we go about rebuilding what was once seen as a progressive, rehabilitative, effective system in Victoria, one that not only supported children and young people, but ultimately was able to make the community safer because it actually supported them to stop reoffending. How do we rebuild that? And importantly, and this is where I come back to the narrative, how do we make it possible that our politicians of all different colours think that it's going to be popular and politically acceptable to do that work? Thank you.
Liana, thank you. Our third speaker is Nikki King. Nikki is a child protection lawyer with the Loddon Campaspe Community Legal Centre. She does pretty tough work. I met Nikki yesterday at the office, and she just walked in from court, and we talked about her day. And Kylie Beckhouse last night, family lawyer, talked about vicarious trauma experienced by family lawyers. And look, I was getting vicarious trauma just listening to Nikki talk about her work that day. So it's kind of third-hand kind of effect. Every day, Nikki has to deal with questions of whether a child should stay or be removed from their families. And we're talking about the most marginalised and vulnerable people you can possibly imagine, or even possibly can't imagine. And there is, of course, an intersection, as we've heard from the statistics this morning, between complex social problems, care orders, and criminal offending. So would you please make Nikki welcome?
We've heard Liana and Claudia directly on the topic of our treatment of children in the criminal justice system, and I just want to take us a few steps back from that central topic today to look more closely at how these kids end up in the criminal justice system and that overlap that we've touched on already between care and custody. I hope in doing so I can provide some additional context and understanding about the complexity of this issue, because there are no easy answers. There are only answers that involve a significant commitment of cash and political will to fund meaningful early intervention services that can walk alongside families to build skills, connect them with services and provide therapeutic support. The children, young people and families that we meet in the Children's Court are the most vulnerable in the community. Parents frequently struggle with a range of issues, including poverty, mental health problems, drug issues, family violence, sexual and physical abuse and criminal offending. Parents involved with child protection have all too often experienced intergenerational poverty and involvement with child protection authorities themselves as children. Children living in these circumstances often have limited access to resources and services to change what can sometimes seem like a settled life trajectory. His parents were on drugs. His mum was unable to protect her children from family violence. They then became homeless. He was sexually abused. He was removed from his mother's care. His dad then went to jail, but his mum worked hard. She got him and his two siblings home for a while before he went back into the system after his mum became involved in another violent relationship. By this time, he was angry. He was in late primary school, but he wasn't really going. He cycled through a number of foster care placements, being moved on because he displayed sexualised and trauma-related behaviour, including aggression. At 13, he went to residential care, a home for up to 6 teenagers where they're supported by paid carers. He hadn't seen his family in a long time, as he'd lived in Melbourne since he was 10 and his family were in regional Victoria. One of his brothers had been sent to live with an auntie in New South Wales and the other was in another residential care facility. In frustration and distress, he damaged property at the residential care home. He threatened staff, who called the police. The situation escalated and there was more property damage. There were multiple charges. He got diversion on this occasion, but the acting out continued. He was then charged with more property offences while in resi care. He smashed a TV, he ripped a phone off the wall, before he absconded completely and started committing more violent offences, including a burglary that he committed with a mate from the residential care unit. He then went to juvenile detention. This story may sound extreme, but it's not an exaggerated example. Last year, Victoria Legal Aid published a report called Care, Not Custody, in which they reviewed their child protection client data statewide, finding that almost 1 in 3 young people that are assisted with child protection matters who are placed in out-of-home care were later charged with criminal offences. Young people placed in out-of-home care are almost twice as likely to face criminal charges as those who remain with their families. And young people in out-of-home care are more likely than other children to be charged with criminal damage for property-related offences. So there's a big link between being in out-of-home care and criminality, sometimes called the care-to-crime pathway. Kids in residential care particularly feature prominently in our juvenile detention facilities, and we've heard Liana tell us that 2/3 of all children in Victoria's youth detention centres have come from the child protection system. Given these clear links, we must examine the system and families from which these children have come. There are a number of issues for children and young people in residential care which have received some media coverage over the last 2 or so years, including particularly the inadequate matching of children from different ages, experiences and backgrounds together, poorly supported and casual staff with limited training, and a willingness of staff to call police to manage behavioural issues amongst young people. These factors contribute to young people's offending while in state care. The Victorian Government has responded to some of these concerns by introducing reforms to the residential care system, including plans to reduce the number of young people placed in residential care, using resi care as a short-term therapeutic option, and making sure residential care staff are adequately qualified and trained. These moves seem positive. However, they also must be coupled with guidelines about managing challenging behaviour from young people, so as to, where possible, avoid contact with police and the criminal justice system. But just reforming residential care is not enough. We see the issues that can lead to criminality and social dysfunction forming earlier, with a real lack of early intervention services for parents to build good parenting skills in an intensive manner and outside of an assessment and investigation setting. Our services acted for many mothers who have their children removed shortly after birth as a result of protective concerns, including drug and alcohol abuse, poor mental health, and in the case of more than 3/4 of the women we act for, family violence. If these parents are not from families or communities who can provide any level of support, they will be wholly reliant on professional services to get on board quickly and assist them to address the protective concerns. In regional areas particularly, there are lengthy waits to get into detox and rehab. Without children in their care, these mothers are often ineligible for the support of a family services worker. And if skills development is an issue, what will be offered is a 10-day residential assessment and skills development program. In Bendigo at the moment, we're waiting 3 months to access the only service that provides this program. There are no programs that I am aware in our region that can build parenting skills and simply model appropriate parenting behaviour during contact visits. There's a critical shortage of services in this area, particularly services tailored for parents who may have a disability, as do nearly 40% of our child protection clients. So what do? Once children enter our child protection system, we've got an obligation to provide care and support like a good parent would. This support shouldn't end when these kids become teenagers, have problems, act out, commit offences, or reach the age of 18. Thank you.
We're now going to have a moderated conversation with our speakers and with you. I'd like to just start with a couple of questions before we open up to the conversation. Liana, do we know who was sent to Barwon? We know that Indigenous children were not, because there was some recognition that they shouldn't be placed there. Can you tell me, were they the worst of the worst, the rioters who did the damage, and what was their profile? And was it a question of them needing to be restrained in a way that perhaps was not necessary for other children? I think that's the argument.
I'd say that a couple of things. Certainly the messaging around the time that children were first and young people were first moved into Grevillea was that it was a response for those who'd been the ringleaders and involved in the November riots and incident, and certainly that was some of the cohort who were moved in, but both then and indeed over time, it was a far broader group. The criteria for which those decisions were made were said to change a bit and develop a bit over time, but certainly I looked at this most closely from memory in December, at a point in around mid-December last year, and all of the young people and children who were in Grevillea, some of them had been involved in at Parkville in November, a large number hadn't. What was common is that they had mostly been involved in incidents either at Parkville or Malmsbury, so there was an extent to which they were being moved there because it was seen that they were hard to manage in the other two centres. But that was pretty varied. One of the really constant features of my own visits to Grevillea and those of the Commission staff was that often the kids didn't know why they'd been sent there, and they listened to the media, they accessed the media as well, so they would often say, I wasn't even at Parkville, or I wasn't even involved in the riot, I don't know why I'm here. So that was something that was really concerning. They thought that it was only the kids who'd been involved in the riot that should be moved there or were to be moved there, and they had a level of confusion about that. The other thing that's probably worth commenting, I mean, I think the way that the cases played out and the fact that government settled the very first case on the basis that no Aboriginal children would be transferred to Grevillea without a view from my colleague, Andrew Jackamus, the Commissioner for Aboriginal Children, that a transfer to Grevillea would be in an individual child's best interests. That meant obviously no Aboriginal kids were in Grevillea after that decision, which from memory was late November. But that didn't mean that you saw an incredible diversity of children and young people in Grevillea. There were absolutely points in time where, certainly when I went, and the Commission staff would tell me the same, that either most of the kids there were African Australian kids, or there were maybe a cohort of African Australian kids and a cohort of Islander kids. There were some times that there were very few kids of Anglo background. So we haven't looked in detail at why that was, but it was pretty striking.
That is striking. I'm wondering, was the choice of who was sent or not sent about who gets on well together, and issues around cohesion? I don't know. I want your comments.
No,
on
I
that.
think, look, again, I think my observation was that those factors were taken into account more as the months passed, and that was reflected in the fact that as the months passed, the unit became more settled. There was quite a marked change in the approach to managing the unit around the beginning of March. But over time, certainly, it does seem as though factors about who is going to mix well together, given that it's a very contained space in there, there's not much capacity to get away from people you don't get along with. I think that was factored in more in some of the placement decisions.
But certainly the fact that people are coming from two tiny communities in Victorian's demography is a cause of concern. Claudia,
my colleagues who ran the litigation and visited Barwon reported very similar to what Liana was saying. And during our advocacy around our litigation, we certainly at various points made it clear that there were children there who weren't involved in the riots, that the Premier's assertion that it was the bad kids, the naughty kids that would be moved to Barwon wasn't the actual full truth. And so it did create lots of, issues that Liana has just outlined. The young people do listen to the media. They do get affected about how they're being portrayed and discussed. And absolutely there was a distinct lack of Anglo or children from Anglo backgrounds that were in the Grevillea unit at Barwon.
Before I go to your questions, just one thing that I think is really important to kind of tease out. There's been a shift in the responsibility for children in detention from the Department of from DHS through to the Department of Justice. I just briefly, before we go to questions, I'd be keen to know if the three of you have views about that shift. And given all the problems at the Parkville and the other ones, DHS perhaps weren't doing a fantastic job. So briefly, I'd be keen to get the views of the three of you.
Yeah, I guess in an ideal world, you would want the youth justice system to be housed within Department of Health and Human Services because of those links that particularly Nikki described around child protection, residential care. It makes sense that the staff and the policies are dealing with the same cohort. But yes, I mean, you've recognised that it wasn't working. I think that was the big key. Why did the riots occur in the first place? So I guess what we would say is if a move within corrections can be done in a way that the rehabilitative focus of our dual-track system, the youth justice system, can be refocused in that way, then we'd hope that would occur. But I guess certainly we're not 100% confident that we're going to get that kind of focus with the system being housed within corrections.
Now, I've just realised how running short of time we are, so we might even go to first. Oh, we've got three. Okay, so
can I just say, just very, very quickly?
Go, Liana.
I think I agree with everything Claudia said. So I think we've got a bit of work to do together. People who care about keeping a separate system to make sure that, notwithstanding the move to justice, that there still is that separate focus. I think there's some really positive signs that there's at least a level of commitment to that. The fact that it's actually not being run by corrections, it's being run separate to corrections, albeit still within justice. And in fact, there are some signs that at least some of the regimes that I've described, including, for example, the younger children being handcuffed whenever they move out of their unit, since the move to justice, there's been a level of fresh eyes that have changed some of those processes. So it's early days, and I too am very cautious. But I think the work we've got to do with the Department of Justice is to make sure that separate focus is maintained and that there's genuine rebuilding.
Okay, question. With 80% of young people in Parkville on remand, how many of those are sentenced to a term of detention in a youth facility? Is it not a great majority? How can bail tests be redressed to reduce overcrowding? A couple of points there, but I think they're really interesting, that idea that all these kids are on remand. I
can tell you the last time I asked the question, of those the kids who are on remand, what happens when they finally get their matter dealt with? And the answer at that time, it's a few months ago now, the answer at that time was that 3/4 do not receive a custodial sentence.
Oh. Okay, that's extraordinary. Okay, this question: who in the world is leading the space of prevention in providing support, the support that kids at risk need? Is anyone getting it right? And what does the panel think about the approach in Finland? As a community, what can we do? A few questions again there, but Nikki, do you know if anybody doing it better than we are?
I'm perhaps embarrassed to say that I'm not sure what the approach in Finland
Me too.
is.
Yep.
But I certainly think there are great services in the community. The problem is there's just not enough of them, and there's often significant wait periods for people to access those services. And I suppose the services that we see in the child protection space are often focused on investigations and assessments, and those services get involved once kids have already been removed. So I suppose if you look at the circumstances that can lead to people becoming exposed to child protection involvement and involvement with child first services, those issues start very, very early in life. So I suppose we would really like to see some more investment of funds and resources earlier, so that there can be more meaningful services at that particular stage.
Another question, and this goes, I guess, to the kind of the culture that and the kind of the political and social context in which these sorts of decisions are being made. How does the panel does the panel have any suggestions regarding how concerned community members can start to challenge both sides of politics to abandon the tough on crime rhetoric in favour of effective evidence-based approaches? Keen to get all three of you on that one.
Yeah, I guess your local member of parliament's a good place to start. I think that often when you hear what's reported in the mainstream media, it's the community thinks this, the community is scared, and so they make it very one-sided. So I would have thought community members speaking to their local members of parliament and asking questions based around what the evidence says, not just the rhetoric that's necessarily reported. I would suggest that's a good place to start.
I agree with that, and I think have no illusions about the power of mainstream media in influencing policy and political debate. So engage in talkback, write letters to the papers, even if they don't get a run, just keep writing them, because I do think that's all important. I also think there's an incredible gap. We get the stories, very real stories about how victims are impacted by offending of all sorts, including youth offending. And they paint a level of human pain, and they incite fear and compassion, and for very good reasons. But we don't get the stories of the children and young people like Nikki described, and like I see in the inquiries I do, including the inquiries into the cases of children who die who've been involved with child protection, for example. Those stories aren't out there. So any of us who work with clients who experience some of these issues, we've got to find ways, and it's not easy, we've got to find ways to get those stories out there.
We had a conversation last night about Section 121 of the Family Law Act and how you're protecting the privacy of kids. Same goes for you guys. I try, and people say, well, we can't, let's have another conversation, guys. But that is very difficult for the media, It's very difficult because you're not hearing those voices in the same way as you hear victims. And I understand that there are totally legitimate privacy reasons for that, but that is a problem for the media. Narrative-based media needs that stuff. It's a conundrum. I just want to identify that. Look, do we have a one or two questions? I'm afraid we don't have much time.
Just in response to Nikki King, the care to custody research that you referenced, I understand that in New South Wales there's a protocol between police, I think, and child protection services to try to clarify the circumstances under which referrals might be made where a child's in a residential facility. Is there such a kind of arrangement in Victoria, or is there any progress towards that?
There's not at this stage, but I certainly have read about the approach that's been taken in New South Wales, and the Victorian Legal Aid report in relation to this issue really highlights that it's something that Victoria really should be focused on as well, and I wholeheartedly agree. I think there does need to be a protocol, because I think all too often we see that is the first contact young people have with the criminal justice system, and it's minor property offences that are committed in residential care, and things escalate from there. So really critical that there's a therapeutic approach taken, and that the support workers in resi care, who have an incredibly difficult job, are adequately supported and trained to be able to work therapeutically with the young people that they're supporting.
There has been, as some of you in the audience might know, there's been some conversation about working towards a protocol of that sort in Victoria, and it's not rushing ahead, but there is some quiet work underway. I think one of the really positive things is that the community service organisations that run a lot of the residential care homes, for example, are beginning to recognise, partly because of that work by Legal Aid, are recognising that there is a problem to be addressed. So they're on board with doing some work. We just need to get all of the players to the table, I think.
We're right on time. We have time for one more question.
I'd like to address my concern to Nikki. As far as parent education goes, there was a service that was there waiting to educate parents. It's the Maternal and Child Health Service, and instead of seeing people 25 times in the first year, they now see people 10 times in 5 years. And before I retired from that service, I was setting up fathers groups for relationships and to deal with the exact problems that you're talking about. And it's still there, and it just needs money.
Yeah.
And I'm so passionate about parent education in the interest of justice for adolescents.
Yes, look, sounds fantastic. I mean, I'm absolutely aware of the great work that particularly the enhanced child maternal health nurse services do. We frequently hear from clients who say that it's been a really valuable support to have that connection, but like you say, it's not enough.
And I was just going to say, I don't want to sound like I'm spruiking for government here, and it is interesting to hear that long-haul view about the wind back of maternal child health services. We see the relevance of those services in our child death inquiry work. I can't describe how much, but certainly in the last budget there was $80 million announced. That is to at least boost the enhanced maternal child health, make that available statewide and make it available for a much longer time. So it's not getting us back to what you're describing, and it needs to, but it's some recognition, I think.
We have time for one more text question, very short, just to you, Claudia. What process does the Fitzroy Legal Service follow to ensure that those involved who were part of the litigation were involved on the basis of informed and knowing consent? So I guess, how do you know that the people you were acting for wanted your involvement and consent in the action you took?
Yeah, good question.
Good question,
I mean,
but, yeah.
we absolutely must have clients as part of our any litigation that we do. So we have lots of involvement with young people in the criminal justice system, as I said, representing, and part of that was discussing with them about their experiences and whether they wanted to be involved or not. We had a litigation guardian because they were under 18, so very much cognisant of that aspect of dealing with young people.
So they were involved. They were making an informed decision to be part of the litigation.
Yeah, so my staff spent many visits to Barwon talking to the children.
Okay. It's been a fantastic session. I'm afraid that's all we have time for. We could have talked for much longer, but I think the time was, every minute was great. So look, would you please help me thank our panellists, Liana Buchanan, Claudia Fatone and Nikki King. Thank you very much.